Okay. Well. Oh boy, Ed. Good morning and welcome to AM News Network presents the Morning Report with Rachel Baird and Ed Peruta. I'll be joined shortly by Ed Peruta. We do our show every Monday through Thursday from 7 to 7:30 a.m. Please join us as well on Saturdays for our Summary Judgment Show, which Ed and I did by ourselves last Saturday because 3 of the 5 Summary Judgment crew members were missing. I guess it truly is the summertime when you have that many people missing, huh, Ed? Well, we look forward to them being back this Saturday.
Good morning, Rachel.
I was just at SCOTUS blog, of course, getting ready for 9:30 when they're going to tell us what orders issued today, especially from the conference that was held last Thursday, where supposedly your case, Peruta v. California, was discussed again, or held in abeyance, or whatever happened. So we're going to wait for 9:30 to see if there's any word on that. I know the people at Masterpiece Cake Shop involved in that case, they've been waiting longer than you.
I should call them up and order a cake.
But while I was at SCOTUS blog, do you remember that case, Alonis v. United States? A couple years ago, it was that case out of the Third Circuit of Pennsylvania. It went to the Supreme Court, and the Supreme Court declined to rule on whether you could recklessly make a threatening statement.
Yes.
And I had brought that up in the Ted Topier matter.
Yes.
And what the Supreme Court did, and I just noticed this, so I'm going to have to refresh myself on this case. What the Supreme Court did in overturning Mr. Alonis's conviction was send it back down for reconsideration, and I guess it went back down, and Mr. Alonis lost again because it appears from the Third Circuit decision that it took into account what the Supreme Court said, and it said subjective, objective, it doesn't really matter what reasonable person standard you go by. Anybody would have found those threats threatening, and by the way, there's no way he didn't know they were threatening when he said them. So case closed, harmless error, Mr. Alonis loses again. So Mr. Alonis has now filed a petition for cert to go back up to the Supreme Court, and I'm looking at the Third Circuit case, and it says, our disposition on the issue of harmless error decides the case. In other words, maybe there was a screw-up, but it didn't matter because he was so obviously guilty, it doesn't really matter if we screwed up. But here's the important sentence for the point I was trying to make in the Ted Topier case. Accordingly, we have no occasion to determine whether a finding of recklessness would be sufficient to satisfy the mental state requirement of Section 875C. We leave that question for another day. And that is the question. If a threat means an intent to convey something to somebody else, how can you recklessly threaten somebody? How can you recklessly threaten somebody if it's your intent to threaten them that's part of the element of the charge? And I'm glad to see it's going back up to the Supreme Court, because if the Supreme Court takes it this time, maybe they will decide that really, really important issue.
The way I understand it is this, and I could be wrong, but I'm going to go with it anyhow. When you make a statement containing words to John Smith in California about Bob Jones in Connecticut, how can it be a threat against Bob Jones in Connecticut if you never intended it to go beyond Smith in California? There was the intent. I believe that's what Alonis was saying. In other words, the words were not directed to that person. It was directed to somebody else. Where's the intent for?
Well, I'm trying to bring up the motion that I wrote, but actually what I brought up is Judge Gold's memorandum of decision on my motion to dismiss, and it kind of renews my recollection of this. The defendant's constitutional challenge is premised on his contention that laws that seek to criminalize the making of allegedly threatening statements will comport with the First Amendment only if those laws require proof that the defendant specifically intended to threaten the victim. That was my position. That if you can convict somebody for threatening without finding that they specifically intended to threaten the victim, then that does not comport with the First Amendment. That was the argument. And then in support of his claim, the defendant relies first on the United States Supreme Court's recent decision in Elonis v. United States, and that was a 2015 decision, and then on a handful of pre-Elonis cases, and it goes on. So you know what? We need to catch up, because this is quite a development, I think, to see whether the Supreme Court's going to again address Elonis and fill in the blanks of what they missed last time.
I got into this a little bit on Saturday during summary judgment. The fact that we sit on this side of a camera and there's people on the other side of the camera who listen to our discussions, I'm sure that they do the same thing that I do. I listen to you, and while I'm listening to you, I'm running various scenarios through my head to try and find something to refer to describe or to explain what I'm thinking, what you're thinking, what's going on. Now, there are times when threatening is absolutely justified. And I'll give you the example. You have a young buck, and I say young buck, I was a young buck, come into your combat unit, and you give him an assignment to go out and do something. And he says, I ain't going out there, I'll get killed. And you take out a .45, you put it to his head and say, die there or die here. You know, I'm going to blow your fucking brains out if you don't do this goddamn. Somebody has to do it, and you got to do it. It's your job. Now, that to me is a justifiable threat. I know in my lifetime, I have walked into public buildings and been so emotional and upset over the way I was being treated when I knew the law. I knew I was right. That, you know, you almost have to say to somebody, you know, I'm about ready to come over that desk and kick your fucking ass if you don't listen. You know, check it out. And here's an example of that. The infamous, and I'm not going to get into it, the infamous chicken tax. I read a bulletin that came out from the Department of Revenue Services in Connecticut. Bulk food sold in a grocery store is tax exempt. Buy a drumstick, you get taxed, single portion. Buy the whole bird, it's tax exempt. I called Big Y Supermarket's accounting tax office in Springfield, Massachusetts. And I kept saying to the woman on the phone, read your bulletins. You get them like I do. Call the Department of Revenue Services and ask the question. I've called, I've asked, and they've given me the answer. Why don't you call, ask the question, and see if you can get the answer? And they refuse. Now, I don't know whether government and businesses today are training people and paying people to be vague and ambiguous and just go with the line. Don't listen to people that call in. Just do what we do. But I can understand, now that I've been exposed to it, the frustration that litigants in the family court have with the system. It involves property. It involves children. It involves retirements, people's retirements. It involves the ability to survive financially into the future for both parties involved in the litigation. It is a cesspool of issues in the family court, and it could be streamlined. It could be made more efficient, simpler, and people could understand going into a marriage what can happen coming out of a marriage. They don't. So this aloneness case, the whole issue of threatening, people are, you've said this before, people are trying to desexualize the population. In other words, men should be more like women, women should be more like men, and you're losing some of the human traits. They're trying to change humanity. And I don't think it's going to happen.
Maybe it's evolving naturally on its own. There's a concept that when there was more of a reliance. Well, let's say I don't know how we got into this subject matter. It's
Aloneness.
Far afield.
Aloneness and the threats, the words, and what society is expecting. How did aloneness even get where aloneness is? Was it a valid threat, or did I just perceive it as a threat? Go back to openly carrying a firearm in Chili's. Well, it made people upset, but it's legal. How do you get away from that? How do you get away from that, Rachel?
Okay, so aloneness. According to Judge Gold, and I'm looking at his memorandum of decision because that's the first thing that came up when I searched on my computer for this case. But aloneness may be seen as more important for what it did not decide than for what it did, and that's what I'm saying. And I'm glad it's going back up because maybe it'll decide what it didn't decide. First, let me see. Aloneness did decide that proof of negligence alone is not enough to support a conviction under the federal threatening statute. So negligence isn't enough. Intentional conduct is. What about recklessness? What about recklessness? That's what it left open. Can you recklessly threaten somebody? The court did say that wrongdoing must be conscious to be criminal. It also stated there could be no dispute that the mental state requirement of the federal threatening statute is satisfied if the defendant transmitted communication for the purpose of issuing a threat, or with knowledge that it would be a threat. That's intentional conduct. However, as Justice Alito pointed out in his concurring and dissenting opinion, the court holds that the jury instructions in this case were defective because they required only negligence in conveying a threat. But the court refuses to explain what type of intent was necessary. Ted Topier was convicted for recklessly communicating a threat. Does our law in Connecticut that allows a conviction for reckless communication of a threat violate the First Amendment to the United States Constitution?
If my memory serves me correctly, there was never any evidence presented of Ted Topier's intent for Judge Bizzuto to receive those words?
You know what? I don't care. I don't want to get into that. The charge was reckless, so it doesn't matter.
Right.
The charge. I'm looking more at the big picture, Ed. Does our law in Connecticut that allows a conviction for a reckless threat violate the First Amendment, no matter who is charged with it?
Okay, well, let me just wrap up what I was going to say. If I remember correctly, when Alonis was first came out, and they haven't changed that one section you were referring to. You cannot claim that your actions were reckless if in fact you intended to do what you did. In other words, you can recklessly move towards it, but when the actual act occurs, if you've planned it, it's intentional. But you can't be intentional if all you have is reckless. Does that make sense?
Right.
In other words, you need more than simple recklessness to...
Okay, here we go. I found the paragraph that I wrote. Let's see, because it's so hard. A standard that permits convictions in criminal prosecutions for speech attributed to a reckless mens rea, intent,
mental state,
is inconsistent with the recent United States Supreme Court holding in Alonis and violates the First Amendment. I wrote this. I just want to make that clear. I'm not reading somebody else's decision right now. Alonis requires a subjective intent to threaten, but left undecided whether recklessness is a sufficient mens rea to separate wrongful conduct from innocent conduct in threatening cases. Recklessness does not involve intentional conduct because one who acts recklessly does not have a conscious objective to cause a particular result. A person alleged to have threatened another recklessly does not have the conscious objective to terrorize another person or to inconvenience, annoy, or alarm another person. At most, such a person has a conscious objective to take a risk that what they say is a gross deviation from what a reasonable person would foresee that another reasonable person would interpret as a threat. Okay, got it?
You know something? I do get it. But now, let's look at Judge Gold's decision in Topier. That decision was reached
2015?
In 2015.
Yeah.
Okay? He was convicted.
October 2nd, 2015.
He was convicted on October 2nd, 2015.
Well, no, that's not true. This is Judge Gold's memorandum of decision. I think Ted was convicted before that.
Okay, well...
God, now I can't remember.
Okay, but you know something? It doesn't matter right now. Let's look at
before
Ted Topier, October 2015.
Yeah, that was long after his conviction. This was a post-trial motion.
But let's just look at Ted Topier, convicted prior to October 2015. I want you, off the top of your head, to start thinking about statements that have been made by prominent individuals.
Oh.
Madonna wants to blow up the White House. Johnny Depp wants to assassinate a president. There's a politician that thinks that all of the people that got shot in Virginia should have been killed. I mean...
Kathy Griffin.
Holding up a head.
Can you imagine if somebody did that to somebody in Connecticut?
Now, what I'm saying is this. Let's look at all of the statements that we know about that rose to the level of being reported on a national scale.
You know what I think? I think Donald Trump is in the same category as the first selectman's wife.
Right.
The first selectman of Basra in Connecticut made threats against his wife, wrote letters, laid in wait. His case got dismissed, no problem.
Wouldn't it be great?
So you can threaten Donald Trump all you want. The first selectman can threaten his wife all he wants, and And it's no problem.
But don't threaten a judge.
Don't threaten a judge.
Don't threaten a judge.
Because when you're charged with threatening a judge, you're going to be sitting in front of a judge. Don't threaten a judge. You can threaten Donald Trump. You can threaten just some first selectman's wife because she's only a wife. I don't even think she's a lawyer, definitely not a judge, so who cares if she's threatened, right? You know, you can threaten these kind of people, but don't threaten a judge because then you're going to be sitting in front of a judge deciding that.
And I want to add this to that statement.
Right.
We are on this side of the camera, to the people on that side of the camera, to as far as Bangkok, Thailand, at least for one viewer that watches.
Yep.
What we're talking about today is a national issue.
It certainly is.
It is a worldwide issue. When you've got that little shit in North Korea making threats against us, you know.
In the context of the First Amendment, recklessness does not suffice as a mens rea to separate wrongful speech from protected speech. A person alleged to have threatened another recklessly does not have the conscious objective to terrorize another person. At most, such a person has a conscious objective to take a risk. Okay. The chilling effect on speech arises from criminal liability for disregarding a risk and making a statement, especially statements that address public issues and persons, renders the right to free speech captive to determinations by government officials of whom to arrest based on determinations of what a reasonable speaker should have foreseen would be the reaction of a reasonable listener. Recklessness as a mens rea applicable to criminal acts that do not implicate the guaranteed right to free speech under the First Amendment may be sufficient to separate wrongful conduct from innocent conduct. However, the application of recklessness as a mens rea when the act is pure speech criminalizes protected speech and chills speech that otherwise would be spoken, but for the fear that the speech will result in arrest when subjected to an objective test of what a reasonable speaker should have foreseen would be the reaction of a reasonable listener.
Now that was
that
was a little wordy, but yes.
Yeah, well, I think it underscores the ridiculousness of applying a reckless mens rea to a threat.
Yeah, well, there's a couple of things that I want to get out during this show, but I'm gonna go this far, okay? We went through a political campaign prior to November 8th, 2016. We went through a situation where a number of candidates went to the podium. Now, I want you to understand, because this is the way I now picture it. Donald Trump got up there and may have made some reckless statements, but he didn't sit there and probably with no intent to do anybody any harm.
Because reckless statements are subject to a measurement of what an objective or subjective listener would think about that statement. So you have that one layer that you have to get beyond.
I know you're going to agree with me. The other candidates who were on stage with Donald Trump, who's that?
It's Dan. Let's just key him in here. All right. Hey, stand by, Dan. Good morning.
Good morning.
Well, good morning. And this is not Bangkok, Thailand, but, you know, West Columbia, South Carolina might have to do today.
Okay, but let me get done with this, and then I'll give you some time. The other candidates who were on stage with Donald Trump, either prior to going up there, met with their people and said, you can't make reckless statements. You can't say this. You can't say that. What would the debates have looked like if every candidate went like this? Hold on.
What might somebody
think
of this?
Wait a minute. You've asked me a question. Hold on so that I can really think of an appropriate answer that will appease people but won't piss people off.
I got to think about
it.
About what a reasonable person may think about,
perceive of what my answer,
of what I'm
right.
saying.
In other words, Donald Trump went to the podium without fear of making a reckless statement because he was talking off teleprompter, off script, nothing in front of him, and I said that during the campaign. This is a guy that's going to a podium and speaking from inside, not from a piece of paper.
Okay, you're going hoarse.
I know. I need to just say something.
Okay.
Then I filed an FOI request with the state of Connecticut for all of the rules that prohibit conduct in the courthouses. They gave me 11 pages of rules where certain activities are prohibited. The bulk of those rules apply to jurors. I don't believe there are any rules, but I'm still looking. But I just want to let everybody know we did get a response from judicial, and the rules are like rules for jurors.
Well,
go ahead, Dan.
And I know you had pointed out one important rule to me that we should get out to the public as soon as possible in case anybody's called for jury duty in Connecticut. You cannot wear tank tops if you are a juror, okay?
Right.
So put the tank tops away.
And another breaking judicial event. Everybody knows that I bitched because they wouldn't let a female marshal search me to get up to the courtroom to assist you in a trial. I have now learned that all I have to do is say to the marshal, I recognize myself as a female.
Look, we have our same outfits on.
Okay,
Dan,
yeah,
what's up?
Go ahead.
So that's funny that you just noticed that you got the same outfits on, because I noticed that this morning too.
Dan.
The same outfits on the sign, but that's not why I called.
Okay.
So it seemed to me as if a good portion of the show really was dealing with the issue that I've heard you touch on before about the fact that the House is always going to win. They are going to manufacture an opinion or a decision to suit the outcome of the circumstances that they want. And so, like you say, if it's an accusation that deals with a threat by a first selectman who, and if I recall correctly, that particular first selectman used to work in law enforcement, did he not?
Yes, retired. Yeah, I believe he was
Retired state police.
Yep.
Yeah, and so and that's what to me has been the most disappointing. And even as somebody who's come into this with 9 years ago with no experience or involvement or interaction, and to realize that this is what the justice system or the alleged justice system is all about, which is outcomes that are kind of predetermined to address an issue. Even for the Supreme Court or an appellate court to say, we're going to leave that question for another day. I question why. I mean, if there is a question before the court and a substantial likelihood that that question is going to be presented yet again, why not resolve the legal question?
Yeah, because the case is going right back up there anyway, and there's people like Ted Topier sitting on house arrest that really need to know the result.
Dan, I need to say something and I want this on the record. I've told you the story about what happened to me in the fall of 1981.
You might have to be a little more specific.
I had an incident where I ended up in court. I don't know the judge's name. Can't remember. Case was dismissed.
The one down in Florida?
No, the one in Wethersfield.
This was the judge that was good to you, right?
I had a judge ask me if I would do him a favor and go to a vet center in Hartford to speak to somebody at the vet center. He had asked me, are you a former policeman? Are you a former Marine? Were you in combat? And post-traumatic stress was a brand new thing going on. And I want to go on the record as saying there's at least one judge, and I'm sure there's others, that are very good, very compassionate, and that judge saved my life.
Well, I don't think our viewpoint's ever been any different on the show.
I think that there's a lot of judges who get caught up in the bullshit of judicial, and they're worried about being reappointed, and they seem to go off track off the justice track.
Well, I mean, isn't it the same theory with police officers? You know,
Yes. Yes.
We have never, ever held the opinion that all police officers are bad, or even that the majority are bad.
Right. We got a lot of friends that are policemen.
But our position is that the ones that do tend to go over the edge or work outside the lines, they're not called out on it by anybody.
Dan, when are you coming back?
I will be back for Wednesday morning show. I'm coming back tomorrow afternoon.
Well, I'm going to tell you, we need you bad. You are an integral part of what goes on here, and we have missed you greatly.
Now, we have no pictures to show people. I would have showed pictures of the new dog today if Dan was here, but we have no capacity.
I think it's important that from time to time that the members of the team remove themselves from the show and watch it like regular viewers would, because I've noticed things that concern, like I, for instance, don't understand what this weird little red halo is around the astronaut's head. Maybe it's a reflection off of an exit sign, but I have watched the show.
It is.
Yeah, and so I think it's important because these are little things, you know. And as you know, when I watch the evening news on ABC or CBS, I always look to see how can we do what they're doing, or how can we not do some of the things they do.
Okay.
Anyway,
I got to go.
I like that. Okay, we got to close it down. Talk to you later, Dan. Have a good day. I know you will.
thanks.
Bye.
Okay, now I'm going to keep talking, say goodbye, do whatever.
So please join us again tomorrow at 7 o'clock, and everybody have a great Monday. I know where we will be at 9:30. We will be on the SCOTUS blog watching to see if there's any decision in Peruta v. California, whether the court takes the case up or not. Have a great Monday.